Oh, we're on. Hi. How y'all doing? It's me in Chicago. I got some good clips. I can't remember what's in there. It's been a busy day, but there's some good stuff in there, and we even have a SovCit that might take a plea. Let's get it going, shall we?
All right, we're on the record and file 2008-8598, Brandy DeVore and Buford.
Oh, that's right. We have a theme, and that theme is shut your hole. It's a common theme here, but wow, it's prevalent today.
Smith. Oh, wait. So are you there now?
Hello, there we go.
All right. I called the case. Mr. Smith is here. Ms. DeVore is not. This is a date and time set for hearing on Mr. Smith's motion. Sir, what are you requesting today and why?
Okay, I want my new doctor. I'm sorry about missing the last court date. I got the times mixed up. I have a new doctor. His name's Dr. William Weiner. He's an internal medicine doctor. He declared me permanently disabled. I have the letter coming in the mail. I will get it to you as soon as I get it. Plus, I have my federal hearing tomorrow for my disability at 1 o'clock out of Mount Pleasant. So if we can postpone this matter, I don't know, a week or two, so Brandy can be here also, that would be great. I can get you the information as soon as it gets to me.
All right, yeah, she's not here for some reason.
I've been cooperating this whole time, sir. I have no reason to lie. I'm sorry that I'm disabled and I'm sick, but my legs just don't work no more. I'm having major problems with them.
I don't know that you are lying, but you have every reason to lie because it would improve your position in court. So, okay.
I'm homeless.
All right, can you get your doctor to testify?
I think that's going a little too far again, sir.
Well, the only problem...
Silly judge insisting on, foundations and rules of evidence. I like the condescension. I really do. Just so wrong and so bold.
Yeah, I'm going to get my SSI tomorrow.
All right, well,
you think? It's a hearing. That's not a done deal either, my friend.
Okay, and I'll adjourn this so we can see what happens there.
If that route
letters really aren't as admissible as a lot of people.
They were before. They were before. So what changed now? What's changed from before?
Okay, just listen. All right, your doctor was here to verify those letters before. So
he's not my doctor no more.
Okay,
that's not my doctor. Have a whole new doctor.
I get that. But he was here to verify that those were your medical records and testify about his opinion last time.
He wasn't a doctor, sir. He was a practitioner. Now I see an internal medicine MD.
A practitioner? I think you meant to say practitioner, which doesn't contradict the form. Well, whatever. I won't get into it. It's too good.
Doctor, and he says I'm permanently disabled.
Okay, good.
He told me if I have.
Glad we finally have that. But what we need is the doctor to actually testify, because when he submits a letter, he's not under oath when he writes the letter. You would assume it's true, but he's not under oath, and he can't be. The letter can't be cross-examined. Okay. So
we've been going at this for 13 months now, sir.
That's the only reason I would say you would need to have the doctor testify. I know you don't like to listen to me, but that's how the law works. I'll adjourn this till June 23rd at 9 a.m. and we'll have a hearing.
Okay. What happens with my SSI tomorrow?
What's that?
What's going to happen when I get my SSI? Because that's tomorrow, sir.
You broke up. I couldn't hear you. What?
I said, I have my SSI hearing tomorrow.
Yeah,
what is going to happen after I get my SSI?
Well, presumably, support would be recalculated based on zero income, because
I'm not getting full-blown Social Security, sir. I'm getting SSI.
Gosh, if you would just listen.
Listen, my lawyer already told me. All right, adjourn until when? June what?
So when we run support with SSI, we put in zero income, okay?
Yep, yes, sir. Yes, sir.
So usually
June
that results
23rd, at what
in a
time,
zero
sir?
obligation. But we'll see what happens tomorrow. Get that medical record. See if you can get your doctor to testify to back it up, or maybe
Oh,
someone
he
in
already
the
said
office
he
just
would.
to verify it. And
He already said he
June
would.
23rd, 2023 at 9 a.m. And when you come to court next time, try not to interrupt. You got it?
Yeah, I'm just trying to prove my point. I'm disabled, and I don't know what the problem is.
And I give you a chance to
I'm
speak,
disabled,
but then
dude.
you talk
I
right
can't
over
work.
me whenever I try to explain things.
Because I can't work. You don't listen.
That's not
I've
the
been out of
point.
work for 21
Whether you can
months.
work or not is irrelevant to the fact that you interrupt me throughout these proceedings.
Because
So
you don't listen
if you do
to
it
me.
again, I'm going to require you to be here in person. I won't allow you to appear via Zoom. So don't let it happen again.
Okay.
Yep.
Yep. Yeah, have a great day.
Yep. All right. Bond will continue. Thank you. Oh, sorry. The court does call the case of the People versus Gregory Taylor.
On behalf of the good people.
We're ready in that matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Gregory Taylor. Mr. Taylor, please state your name for the record.
Gregory Lewis Taylor.
Thank you, Your Honor. Today is the date and time set for the probable cause conference. We are respectfully requesting that this matter be set for preliminary examination at the very soonest date available.
I don't know if the parties are in receipt of, but the court has received, I guess, what's been entitled an affidavit of non-prosecution.
Yes, Your Honor, we were sent a copy of that.
Okay. The people be ready to go on the 13th, or you want the 20th?
Excuse me.
One moment, Mr. Taylor.
Would we be able to have the 20th, Your Honor?
Excuse me.
One moment, Mr. Taylor. One moment. The judge will give you a chance. Your Honor,
Preliminary examination in person will be set June 20th, 2023, 9 a.m. That will be before Judge Fresh Hour.
Your Honor, may I respond, please?
Yes, go ahead.
We believe that the 13th would be the most appropriate date. From the affidavit, it appears to us that it is clear that the complaining witness does not want to be a participant in this. If, in fact, it turns out that there's not going to be a complaining witness, then there's no reason for them to go to the 20th as opposed to the 13th. Normally, they would ask for...
I don't know if they know that. I mean, this is... Yes.
As this court is very aware, we don't actually always need the victim to go forward with this case. So I would like some time to look into this, to have my victim advocate be able to speak to the victim if possible, and to be able to see if we can proceed without her. So I would ask for the 20th.
Yeah, and I actually hadn't finished making my argument. If I may please be allowed to do it.
Yeah, go for it.
Thank you. It's my understanding that they have heard from the complaining witness in this matter. The complaining witness has made it clear that they do not wish to continue. Further, there are other factors that are involved in here. Mr. Gregory Taylor suffers from a serious back injury to his lumbar vertebrae, which is causing neurological damage. He's attempted to put in kites so that can be seen. The medical facilities have been giving him Tylenol. He was finally able to get a kite to put in, and they had to up it to, I think, neoproxen. Is that what it was, Mr. Taylor?
Nortriptyline.
Oh, I'm sorry. Nortriptyline.
It's another one, neoproxen. Naproxen was what they did before. Now they changed it to nortriptyline, and they're supposed to add another pain medicine today, moxilin or something like that, but I haven't gotten it yet.
So he is suffering from serious medical issues while he's in the Washington County Jail. There's every reason to believe that the prosecution will not be able to go forward, even if they say that they think they'll be able to proceed without the complaining witness. We'd rather find that out sooner than later, rather than have Mr. Taylor sit in jail with his medical issues for an extra week. this is something that they can expedite given all of the circumstances, given they have this affidavit of non-prosecution, given they have this sort of warning. I believe that in the interest of justice and the essence of preserving judicial resources, and certainly in the interest of not keeping an individual incarcerated for longer than might be necessary, that having them setting this matter for the first available date would be appropriate. This is not an argument I would typically or normally make, but given all of these circumstances, I think it would be very
well. I didn't want to be too uptight about it, but yeah, Lauren Brown's. I mean, he's dealing with the facts he has, but his opening argument is, "Ooh, my client is so bad they've upgraded him from Tylenol to naproxen." Okay, they're both over-the-counter pain relievers.
And we don't usually get these, and I might agree with you, except that this doesn't say that the complaining witness, or to the extent that she is, will not testify. Yeah. All it says is she doesn't want to, but she does understand that she may be compelled to. So I don't know what that means, and I don't know. And I think, in fairness to all sides, because this came in, and I don't know what communication has been had with Ms. Taylor.
I know exactly what it means without being there. It means that his client's got a shot at knocking this out right now because the witness is iffy at the moment. He wants to A, get his client out, and B, push this thing as hard as he can before the witness changes their mind and decides that they will testify. That's what's going on. And he sees that as the best shot for popping them. I can read the subtext real easy.
Or anything along those lines. I'm setting it within the time frame that is by statute. I don't think I'm delaying it in any way, but I'm going to attempt to be fair to both sides in regard to it. So it's 12 days out, and that's where we'll be. So I'm going to leave it on the 20th at 9 a.m.
Thank you, Mr. Taylor. I'm sorry, Mr. Taylor. If you have something to say that pertains to your case, I'd advise you not to say it. If it's something,
it doesn't pertain to my case. It pertains to the prosecution's case.
No, stop.
Oh, that's a new one. I didn't notice that earlier. It doesn't pertain to my case. It pertains to the prosecution case. Well, if it pertains to the case that's pending right now, where then shut your hole.
The prosecution's case involves.
Okay, well, it pertains to the witness.
Then I don't want you to say anything on this record. I'll come and speak to you. The court has made its ruling.
Okay, but sir, you didn't inform them that she also has a letter that she went through the advocate and placed with the court clerk as well as the prosecution that she will not be participating, that she has absolved herself of any responsibility where this is concerned. She's not going to testify.
Okay, Mr. Brown, first of all, and I'm just going to lay this out, and maybe, Mr. Taylor, you should listen to your attorney.
Okay.
Because your attorney is telling you not to say anything to the court. Now you're talking about communications that you're aware of that have been made, or at least purported communications, where the alleged victim says now, unlike the affidavit in front of me, that she will not testify.
Yes, and the deeper implication being, I know she's not going to testify because I personally intimidated her, which is another felony charge. I'm not saying that's the case, but that is what his attorney is trying to get him to stop doing.
Which I don't know, and I'm not saying that you were interfering. It would be a little bit, I'm a little bit concerned that you know that. And so I think even more so that people ought to have an opportunity to look at this and make sure that it is not by your interference that this is occurring. So you probably should have listened to Mr. Brown and just been quiet, because that was not my conclusion at all until you started talking.
Okay.
So, Mr.
Bond
Taylor,
will continue. Thank you.
that you're going that's going to change the ruling that's been made right now. So I would ask you not to make any
We're going to ask for bond, and that didn't happen either. Can I
He keeps talking.
terminate Mr. Brown and request the ability to hire outside counsel from the public defender's office?
Mr. Taylor, you are always free.
If that's what you want to do, then I'm just going to adjourn. I'm not going to set it for preliminary examination. So then what I'll do is I'll just give you another probable cause date. How much time will it take you to get an attorney?
I can't do it from in here. I'm asking to be released so that or put on bond.
Oh, well, that won't be happening. So how soon will you get an attorney?
That's a no.
Just leave Mr. Brown as my attorney then, because then I have to
Okay.
contact the family in order to see if they can find somebody for me.
Okay, then we'll leave Mr. Brown. Do you want me to leave it set for preliminary examination? Because that's what Mr. Brown asked.
Yes. Go
You
on.
do?
Yes, please.
Okay. What?
Yes, sir, please. Thank you.
All right. I'll leave a preliminary examination in place. Mr. Brown, you're still on the case.
Thank you. I do appreciate that.
You're
Thank you,
welcome.
Mr. Brown.
All right. It's been a pleasure. Thank you, folks. Next case.
Ms. Lockwood, if you are speaking, you are on mute.
I do, Your Honor.
Okay, go ahead. What's your announcement?
We have made an agreement, a payment arrangement.
In which case was that?
This is Sheldon Smith.
Guess what? This goes just fine until her client starts talking.
All right. When will you have that consent over to the court?
Again, Your Honor, as soon as possible. I'll get this out to Mr. Sheldon tomorrow. I'm going to email it to him to give him time to review it, sign it, and get it back to me as soon as possible.
All right. So, Mr. Smith, what we're going to do is we're going to set your case down for July 19th at 9 a.m. As long as you all get your consent and paperwork into the court prior to that date, you will be excused. But you will get a notice for July 19th at 9 a.m. Do you understand? You're on mute.
She's got a fun green.
Okay.
Yeah, I comprehend. And just to clarify that, like I said, my argument with her.
No, let's stop right there because you all have come to an agreement. So I don't need to know what your argument is. I don't need to know what you all talked about.
Listen, no, I just made that gesture because I'm, that listening session on the private case. I mean, she's arguing but
Mr. Smith, let me stop you. Have you come to an agreement?
I did, but my question to her, I just want to clarify if that as like I ran out of appeal. Like she said, I did appeal it because I find it was unjust. It was not justifiable. For
Mr. Smith, let me stop you again. And I'm not trying to be rude, but I've got other cases. If you all have come to a consent, there's no reason. Now, just stop. I need you to listen for 1 second.
Zip it.
If you want me to hear your case, I will hear it this morning. Okay? If you're not in agreement, that's how she said y'all have an agreement. That's what I'm understanding. So you don't have to explain what you all talked about. And let me just say this. I know you might want to, but typically in Georgia, if you come to a consent, the court does not hear any testimony on the consent because we want you all to come to an agreement.
Right? That's what I did, which that's what I was asking her. If I had a situation, like I'm stating to you now, like what time period was it? And it was a hostile situation I was in which
Mr. Smith, I'm going to stop you because I don't know what you want me to do. Do you want a hearing? No, I just need you to answer
that. Okay, that was the question. If there was a hearing in front of you to be like, like you're asking for evidence or my statement on the situation, the full-blown situation, is that a possibility?
That's what we're here for today.
Right. That's what I was saying, because I'm on the financial restraint, and the same things I experienced back then after me saving money, I'm being penalized right now to be bankrupt,
Mr. Smith,
and homeless.
I'm gonna mute you because I can't talk over you. I have muted you. The question is, do you have an agreement or do you want a hearing? That's it. I need a yes, I want a hearing, or no, we have an agreement. That's it. Okay, so I'm going to unmute you and I'm going to hear from you. Go ahead. You got to unmute yourself.
In all due respect, my statement to her was like an argument. I didn't know I could present it to you. So that's, or a judge. That's why I was arguing with her and backtracking the time period.
Okay,
so
we're going to have a hearing. Mr. Smith, we're going to have a hearing in just a minute. Okay? You just sit tight. You sit tight. All right.
It gets worse.
Mr. Stuckey, so Ms. Lockwood, we're going to have a hearing on your case in just a minute. Give me 1 second. We're going to reset those. Mr. Stuckey, there was an issue with notice on just those two cases. So that could be why the defendants are not here. I know that they are in default. But we'll still reset them onto a default hearing calendar. Okay?
Okay, thank you. All right. And that's it for me, if I may be excused.
Absolutely.
All right, thank you.
All right. All right, and we've got left Miss Lockwood.
Okay.
All right. So if I take it both of you are testifying, Miss Lockwood, yes?
Yes.
And Mr. Smith? So both of you raise your right hand. You swear or affirm that the information that you provide to this court will be the truth, whole truth, and nothing but the truth under pain and penalty of perjury?
Yes, I do.
I do. Okay. So, Ms. Lockwood, this is your case. You can go right ahead.
So, Your Honor, based on the exhibit that I submitted with the claim, it states, based on the administrative hearing officer decision, docket number 31698A-16, released December the 2nd of 2016, Mr. Smith was paid during a period of ineligibility. This created an overpayment for the weeks ending October the 8th, 2016 through November the 19th of 2016 in the amount of $728. And this is what created an overpayment.
Okay. Mr. Smith, have you seen those documents?
As I was stating to you, in which I thought I had a debatable.
We're gonna get to that. I'm gonna hear from you in a second. I promise. My question to you.
Oh, we are.
My question to you. I just need you to focus on my question for a second. Have you seen those documents? That's a yes or no.
I cannot recall. This is not recent, so
all right,
it was
then say that. Hang on. Hang on. I'm going to hear from you. I promise you.
I'm just trying to get my, my statement correct.
So, Ms. Willis, will you please bring up the documents that Ms. Lockwood is relying on?
Yes, Judge. The document is published.
Okay, and if you will blow it up so that we can see it.
I blurred this on purpose.
Mr. Smith, these are the documents sent from the Georgia Department of Labor to you. And these are their business records that indicate that an overpayment was made to you. And what was the amount, Ms. Smith? Ms. Lockwood?
It was in the amount of $728. There was a small payment, so the balance is $723.
Okay. So $723. Now, Mr. Smith, tell me what you want me to know. This is where you get to tell me everything you want me to know. Now, let me share with you before you start. If you start to talk to me about when you all tried to mediate and go in a room and talk. And what she said and what you said, I'm not interested in that. That is private. That's not for consideration here. But if you want to tell me about why you owe the debt or why you do not owe the debt, I will entertain that. Okay?
Right. That's what I was stating to her, in which I thought it was an argumentative situation. But to remind me, I even forgot about the appeal and everything, because I really wasn't. I figure it just should be reduced, if anything, because I'm trying to go back to the main screen here. 1 second. Sorry. Yeah, I was trying to debate the fact that I've been in a hostage situation for like 10 years, and everything leading up to that job, which I'd gotten, I think, after being approved for my food stamps, is basically people associated with this mafia or whatever that's telling me my IDs are just stolen. So,
Mr. Smith, I need to know what your legal defense is. You didn't answer the complaint. You're in default.
It's compassion. Is a situation which I argued in my appeal. Is that I was only making $9 an hour, in which they stated there, people I'm reporting to, stating that it was a setup to hit me, and my car was damaged.
Yeah, the mafia is always chasing people, $9 an hour people around. for what reason, I don't know.
I'll stop you right there. It sounds like there's no legal defense to the claim against you for $728.
I could just hug the judge for that. I'll stop you right there. What I'm hearing is sounds like no legal defense.
I appreciate it, but I'm not going into
Thanks
facts
for playing.
that don't relate to the case. If you have a legal defense, I will hear it. Right now, I'm not hearing a legal defense. So I'm going to issue the default for $728, and that's going to resolve the case. That's it.
I'm saying, I mean, that's like not fair, man. People are threatening my life under the guns, and I was approved prior to, and there was like years since I was unemployed because of the same situation. Okay. People are threatening me in my life and then tampering my car, in which I had to stop working there. So I'm caught up in a situation in which they're threatening.
I mean, fair enough. They're threatening him with guns. The mafia's involved. I'd stop working there too. I really would. Problem is, nobody believes you.
I'm facing fear.
Mr. Smith,
I'm trying to survive.
Let me mute you for a second, because that's going to conclude the hearing. I've made my ruling, and you have 30 days to appeal my decision. Okay? You might, if you need some help, you might seek legal counsel, but you've got 30 days, and there are some costs associated with appealing the decision. All right? That's going to conclude our hearing. You all are excused. Ms. Lockwood, did you have any other cases?
No, I can't change the bond.
I was okay.
I know. So I would have asked too.
So there's no bond?
There's no bond. Judge Stevenson said no bond, but your court date for you is good because it's June 28th at 9 o'clock, which is one of the earlier ones I'm giving.
Awesome. Okay.
Step to your right to the T.
Thank you.
I have to thank people in court for this. People in court sent me this yesterday. I had a portion of it. I overlapped about 2 seconds of it because it's Judge Van, and I knew there would be nuggets, and there are.
Next.
Oh, wait. I'm sorry, I'm not done. Is there any way I can apply for like help, like rehab?
Yeah, absolutely. Let your public defender know that you like care. There's a lot of options. You got a lot of options if you're in circuit court.
Okay. All right.
Next.
Recognizing you're at the bottom of the barrel is the first step.
Say your name.
Jessica Perret.
Ms. Perret, you're fully court on a violation of probation for what was originally possession of meth, possession of cocaine. You understand those charges?
Yes, sir.
All right, ma'am. I understand you've been given copies of paperwork, advised of your rights. Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No, sir.
You've been ordered held without bond by Judge Stevenson. Your court date is June 28th at 9 o'clock. Good luck to you, ma'am.
Thank you.
Next. Bailey. Read it. Say your name.
Sharita Bailey.
Ms. Bailey, you're fully court on failure to appear for possession of cocaine and paraphernalia. Do you understand those charges?
Yes, sir.
I understand you've been given copies of paperwork advised of your rights. Is that true?
Okay, hold on. Can you repeat that, please?
You got paperwork in your hand?
Yes.
You've been advised of your rights today?
Yes.
Okay. Based on your
My
application, your rights. Your right to remain silent. Anything you say can and will be used against you. Your right to an
Yes, sir.
attorney. If you can't afford one, we'll appoint one for you.
Yes,
Your right
sir.
to make contact with friends and family regarding your case. Those rights.
Those my
They,
right.
they,
Yes, I got it.
they usually read them to you in a group.
She sent them to
Yeah,
me.
she
Yes,
did.
sir.
Absolutely, she did. She's good about that. So, based on your application, I find that you do qualify for the appointment of the public defender's office, and I'm going to appoint the public defender to represent you. So now you have an attorney. Any questions about that?
No, sir.
All right. Judge Garcia is where you held without bond. Your court date is going to be June 3rd at 9 o'clock.
You said without bond?
June 3rd.
Or July. Let's do July 3rd.
Thank you.
You said without bond, sir?
I did say without bond.
Can I say something?
You can say anything you want to.
On the date that I had court, see, when I got picked up on these charges,
Yeah.
North Carolina came and got me May 21st. So I had to do time, sir.
You can't hear him, but that's stop talking about your case, guy. Basically saying stop talking about your case.
Your public defender is advised. Your public defender is advising you to talk to the public defender that's appointed to your case about why you missed court, because I can almost assure you single-handedly the worst reason for missing court is I was in jail somewhere else.
But they picked me up from here.
Well, okay, but that's because you were doing something up there allegedly.
Step to your right. Next. Red X. State your name.
Ms. Ball, ma'am, you're before the court on violation of probation for what was originally 2 counts of meth, 1 count of possession of controlled substance. You're also before the court for delivery of fentanyl and unlawful use of a 2-way communication device during the commission of a felony. You understand those charges, ma'am?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Based on your application, I find that you do qualify for the subject of the services of the public defender's office. I'm going to go ahead and appoint the public defender to represent you. Any question about that? See, when I slow down, it doesn't come out as easy. I don't know why that is. If I go fast, I get it all out. But if I go slow, I trip over it. On the violation of probation, you're held without bond. The delivery of fentanyl is $15,000. The unlawful use of a 2-way communication device is $15,000. Your court date's going to be July the 13th at 9 o'clock. Good luck to you, ma'am.
Thank you, sir.
Step to your right. Next.
Read these things.
Leave.
What you doing? Why are you laughing? Oh, we're switching over. That's fine. Mr. McClellan, you're fully court charged of disorderly conduct and possession of alcohol by a person under the age of 21. You understand that charge?
That is correct.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
Based on your application, I find that you do qualify for the services of the public defender's office. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No, sir.
Allegedly engage in a threaten to engage in any fight, brawl, or riotous conduct. Riotous. Thought that's why you went to the beach in the parking lot of Pineapple Willie's. Good Lord.
No, man.
What brings you down here from LaGrange?
Just on a trip.
Just on a trip. All right.
Yes, sir.
Well, I'm going to go ahead and appoint a public defender to represent you because based on your application, you qualify. Deputy, criminal history on Mr. McClellan?
No history, sir.
Mr. McClellan, how long are you planning on staying here in Bay County?
Not here long. If y'all can help it, I can help it. Not long.
We're not there, but I'm talking about, you gonna come to court Friday?
Yes, sir, I will.
That's what I'm talking about. Release him on his own recognizance. Court date's gonna be June 9th at 8:30. Don't make us come back and get you, because it just caused a whole lot of problems.
You don't see me before 8, sir.
All right, step to your right to the T.
It'll be
Next.
me.
When the green light comes
I'm
on.
Judge Grammer all week, so it'll be me.
State your name.
On Friday. Mr. Allen, you're before the court on a driving under the influence and a leaving the scene of an accident with property damage. You understand those charges?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true, sir?
Yes, sir.
All right, sir. Based on your application, you have indicated you're going to hire your own attorney or represent yourself. Is that how you're going to proceed?
Yes, sir.
Excellent. Deputy, criminal history?
17, 2 FTAs, no valid, and an unarmed burglary in 14. That's it.
Bond set 2,500 on the DUI, 2,500 on the leaving the scene. Date's going to be June 9th at 8:30 with no alcohol. Good luck, sir.
All right, step to your right to the T. Next. Red X. State your name.
Chris Daniels.
Mr. Daniels, before the court charge domestic violence battery. Do you understand that charge?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true, sir?
Yes, sir.
Mr. Daniels, based on your application, you make too much money to qualify for a public defender, but the law recognizes your financial situation may change, in which case you can reapply later. You also have the option of hiring your own attorney or represent yourself. Any questions about these options?
No, sir.
Deputy, criminal history?
Controlled substance in 13 and a VOP on meth in 9. That's it.
On set 2,500. Court date's going to be June 9th, 8:30. No contact, directly, indirectly, through a third party, the alleged victim.
Step to your right, sir. Next. Red X, sir. Step on the X. State your name.
Mr. Whitten, you're for the court charge of battery. You understand that charge?
Yes, sir. I got numbers.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir, I have.
All right, sir. You've indicated you're going to hire your own attorney or represent yourself. Is that how you're going to proceed?
Well, I just don't know for sure right now when it's to it, but I may have to get a public defender for it, so.
Yeah, you may.
He has a public defender on his
I-
other case, Judge.
I do have.
Okay, well, they would probably be able to represent you on this case as well if needed them. All right, on the battery, bond set at 5,000, no contact, directly, indirectly, or through a third party alleged victim. Court date is June 9th at 8:30. I'm revoking release in case 22-4641. Good luck, sir.
All right, thank you.
Step to your right to the T. Come here. T. When the green light comes on, sign. Next. Red X. State your name.
Evers, Justin.
Mr. Devers, before the court on a violation of probation for what was originally DUI. Tag, not a sign. You understand those charges?
Yes.
You've been ordered held without bond. Your court date is June 21st at 1:30. Good luck, sir.
Yes, sir. Thank you.
Step behind him. Next.
Don't worry. Don't worry.
State
It gets
your name.
worse.
Mr. Sandlin, before the court on a violation of probation for what was originally domestic violence battery by strangulation and intimidating a witness. You understand those charges?
Yes, sir.
All right, sir. Let's see. Judge Gay has set your bond at $5,000. Your court date's going to be June 5th at 9 o'clock. Good luck, sir.
Yeah. If I tried the fly guy, I would be arrested. No two ways about it. We all know it.
July 5th.
July 5th. Ah,
All right, step to your right.
I'm trying.
July. Next.
The months are
Red
going
X.
faster and faster.
State your name.
Mr. Graham, you're fully court charged with retail grand theft and organized retail theft. You understand the charges?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true, sir?
Yes, sir.
Based on your application, I find you do qualify I'm going to go ahead and appoint the public defender representative. Any question about that?
No, sir.
Deputy criminal history.
Tennessee.
In addition to this getting worse, we also have Deborah Davis showing up in 3B with the SovCit.
Earlier this year, FTA
saying.
VOP 20, evading arrest, criminal conspiracy, DWLSR assault. 18 FTA attempted second degree murder, it says. Act burglary, criminal impersonation. 17 FTA felony ×3 VOP. Theft of property, 15, and burglary tools.
15,000 in retail grand theft, 25,000 organized retail theft. Court date's going to be July the 13th, 9 o'clock. No contact with alleged victim or co-defendants.
One step to your right, sir. Next. Next.
It's all the guys from here on out.
Yep, you can come on in. State your name.
Mr. Andrews? Mr. Andrews, you fully court charged of possession of meth, possession of paraphernalia. You understand those charges?
Yes.
I understand you've been given copies of paperwork and advised of your rights. Is that true, sir?
Yes.
Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. So you have an attorney now. Any question about that?
No.
Deputy criminal history, Mr. Andrews.
Nothing says for, and that's a domestic ag bat.
Pre-trial release. Court date's going to be June 19th at 9 o'clock. Random UAs.
Slide to your right. Next.
Well played. Well
Your
played.
next state your name.
Mr. Tolan, you're for the court on a habitual DWLSR charge. You understand that, sir?
Sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
Based on your application, I find that you do qualify for the services of the public defender's office. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
Yes, sir.
All right, sir. Based on your application, I find that you do qualify for the services of the public defender's office. I'm going to go ahead and appoint the public defender to represent you. Any question about that? Bond set at 5,000 on the DWLSR habitual. Your court date's going to be July the 24th at 9 o'clock. Sign a warrant for violation of probation case 223891. Good luck, sir.
Step to your right. Next. State your name.
Timothy Lee Weeks.
Weeks, you fully court charged lethal lascivious molestation. You understand that charge?
Yes, sir. Sorry.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
Based on your application, I find you do qualify for the services of the public defender's office. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No, sir.
Deputy criminal history.
No history.
Bond set at 50,000. No contact with the alleged victim. Court date's going to be July the 3rd at 9 o'clock.
All right, step to your right. Next. Next. Red X. State your name.
James Carroll.
Mr. Carroll, you're fully court charged of possession of meth, possession of paraphernalia. Do you understand those charges?
Not guilty.
Excellent. Madam Clerk, please enter a plea of not guilty on behalf of Mr. Carroll.
And whatever else you had.
Mr. Carroll, based on your application, finds you do qualify for the services of the public defender's office. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No, sir.
Deputy criminal history?
Yeah.
Grand Theft Auto 17, domestic 15.
Bond set at 5,000 the meth, 1,000 paraphernalia. Court date's going to be July 13th with random UAs, 9 o'clock.
Let's step
What
to
was
your,
that?
you bond 6,000, July 13th. Step on the T. Next. State your name.
Alan Harris.
Mr. Harrison, you fully court charged of possession of methamphetamine. You understand that charge?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true, sir?
Yes, sir.
All right, sir. Based on your application, I find you do qualify. I'm going to go ahead and appoint the public defender to represent you. So you have an attorney now. Any questions?
No, sir, not right this time.
All right, Mr. Harrison. Bond set at 5,000. Court date's going to be June 19th, 9 o'clock with random UAs. Good luck, sir.
Step to your right. Next. State your name, sir.
Mr. King, you're fully court for possession of methamphetamine, possession of paraphernalia, and a violation of probation for possession of methamphetamine. You understand those charges?
I don't see why I was charged with the methamphetamine because I had no person at all. I wasn't in my possession. It was just in the vehicle that I was.
This guy's good. This guy's good.
It just happened to be in the car you're driving?
Yes, sir.
Okay.
I had no idea it was in the car.
It's amazing. It's weird how that stuff happens.
I mean, I had no idea, but it was in the car at all.
Yeah. You know, I bet you could go look in the vehicles that I drive and not find any meth right now.
I can't explain why they had it in the vehicle, but
it's amazing. I didn't have no person. It just happens that you're on probation for possession of meth, right?
Yes, sir. I understand that. It looks bad.
Hypothetically speaking, could you have fallen off? No, let's not. I'm not even going to ask you. Floyd, I'll stop for you. Mr. King, on the possession of meth, bond's 5,000. The paraphernalia is 1,000. You're held without bond on the VOP. Court date's going to be July the 13th at 9 o'clock. Good luck, buddy.
Step to your right to the T. Next.
Cocaine.
It's almost as if Judge Van wasn't buying that. I don't know. I didn't know meth was in the car story.
Critics. State your name.
Mr. Williams, before the court tried possession of meth, possession of fentanyl, possession of counterfeit driver's license, and grand theft of a firearm. You understand those charges? Yes?
Yes.
I understand you've been given copies of paperwork advised of your rights. You've indicated you're going to hire your own attorney or represent yourself. Is that how you're going to proceed?
I'm going to hire your own attorney.
You're going to hire your own?
I already hired an attorney.
Okay, who is it?
Tyree Screws.
Okay. Deputy Criminal History, Mr. Williams?
Shows he's on probation, but this case happened prior to.
Okay.
And that was for domestic ag and carrying a concealed firearm.
Yeah. On the possession of meth, bond's 5,000. The fentanyl's 15,000. The counterfeit DL is 5,000. The grand theft of a firearm is 15,000. Court date's going to be July the 13th at 9 o'clock with random UAs.
Step to your right. Next. State your name.
Mr. Feo, you're for the court tried possession of marijuana less than 20. Abuse of a child ×3 without great bodily harm. Driving under the influence. And leaving the scene of an accident with property damage ×2. You understand those charges?
This guy's just as weird as you think he's going to be.
Yes, but my kids weren't in the car. There was no kids in the car. That's why I understand that I wasn't drunk. I blew a 0.000.
Wait. Let the judge talk for a little bit.
Okay. I mean, the time to contest it is later, not today.
Okay, I'm just trying to let you know that it happens. Yes.
All right. Based on your application, I find that you do qualify for the services of the public defender's office. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
Yeah. Do I get a bond?
I don't know yet. Deputy Criminal History.
13 marijuana and hash. That's it.
For what?
About that. And this is very out of the ordinary for him. So we're all in a shock.
This happened at school?
He told him in school he took my kids inside and then it happened.
That's not what the eyewitness is saying happened.
I know. My kids
The
are
kids
stating
say
it
it
was
happened
lost,
differently.
and
When we ask the kids, I've heard that.
I know.
I understand it's very serious, and I'm not with that at all. I don't know.
It's weird. These guys hash charged the pot.
Yeah, it's all.
And Judge, I'm going to stress that it was an actual possession. This isn't like the methamphetamine charges other defendants have had. He had it in his pocket.
No, I told him that I had it was in the truck, and I told him it was in the truck.
Hey, you need to talk to your lawyer about the case, not the judge.
Well, I like it when they talk to me, though, boys.
It just doesn't make sense. Half of this doesn't make sense. It didn't happen.
Okay. On the marijuana charge, bond's $2,500. The court date's going to be June 9th at 8:30. On the abuse child, I'm going to give $5,000 on each count, which is about a third of what I would normally do. On the driving under the influence, bond's $2,500, and the two leaving the scene of accidents is $1,500 each, because it really should probably be one. Whether you agree or not, Mr. Feo, my bond on something like this is usually pushing $50,000.
That's crazy.
And Judge,
afford that, sir.
And Judge, I
It's
didn't
not.
hear the
It's not for you,
family.
though.
Are these his children?
See, it's not.
Or do they have somewhere else to be?
They
I
his
didn't hear what the
kids?
female said.
They're two are theirs. Well, one of them's theirs together, and two of them are hers.
I'm gonna ask for only supervised contact with the kids that are his, and no contact with the kids that are not.
Well, you can ask for that. I appreciate you. I also say no contact except while supervised. All right. Court date's going to be July the 13th at 9 o'clock on the felonies. Good luck, sir.
Step to your right. Got mine. Next.
He does a lot of talking, but no hearing. God gave you 2 years.
That's why. It's just weird.
All right.
Thank you.
Have a good one.
Can we go?
Oh, yeah, you good.
13 total. State your name.
Mr. Smith, before the court charge of possession of meth, possession of paraphernalia. You understand those charges?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
Based on your application, I find that you do qualify for the services of the Public Defender's Office. I'm going to go ahead and appoint the Public Defender to represent you. Any question about that? You got an attorney now. Deputy, criminal history on Mr. Smith?
And 22, he had 2 sentences, meth paraphernalia, a VOP sentence, VOCC. 21, less than 20 DWLSR, marijuana over 20, DWLSR, paraphernalia, controlled substance times 2. Nights. His history locally goes back to 2007, mostly drug charges and driving.
Well, I said at 5,000 the meth, 1,000 paraphernalia. Court date's going to be June 19th, 9 o'clock with random UAs. Good luck, sir.
Step to your right, sir. Next. Next. Red X, sir. You step on the red X. State your name.
Mr. Anderson, you're before the court, possession of cocaine, possession of paraphernalia, and a violation of probation for resisting officer without violence. You understand those charges?
Yes.
I understand you've been given copies of paperwork, advised of your rights. Based on your application, I find that you do qualify for the services of the Public Defender's Office. I'm going to go ahead and appoint the Public Defender to represent you. Any question about that?
No, sir.
All right. On the possession of cocaine, bond's 5,000. On the possession of paraphernalia, it's 1,000. Random UAs, court date is June 19th at 9 o'clock. On the VOP, you're held without bond. Your court date's going to be June 21st.
Sir, but my probation is paid off. I don't want to miss it.
But you're still on it, right?
It's misdemeanor. It's misdemeanor.
So, yeah, it's in my case. It's my case.
So I can't bond out of there?
No. You pick up felonies while you're on misdemeanor probation.
I didn't pick up a felony. I didn't pick up a felony.
What do you think cocaine is?
They just did that. They just did that. I've been harassed. They just did that. I just want to go home.
Don't try to BS Judge Van about being on probation when it's his case. He's well aware that. Oh, that was fun.
Well, people in hell.
They've been harassing me for so long, man.
Next.
231 is ready when you are.
State your name.
Robert Regan. In 98, East and West. And 77 and 79. There's options. All right, Mr. Williams, before the court on failure to appear for a VOP for issuing worthless checks. You understand the charge?
You understand your charge?
Yeah.
You understand what you're charged with?
Oh, that's it.
You understand?
Yes, sir. You missed court with Judge Stevenson.
Yeah, because we had that failure, that COVID, sir, and I couldn't go to court. They had us call in, and that's what I did. Yes, sir.
So this warrant's been out for 1 year and 3 months.
Yeah. Yes, sir.
You didn't think something was weird about that?
Sir,
we've been open since.
Right,
we've been
open. Working there. Yes, sir.
We've been open. We're blowing and
like
going up here.
sir.
We've been open to the show has been nonstop for at least that long. So you're held without bond. Your court date is June 28th at 9 o'clock.
All right, thank you, sir.
Step to your right to the T. Step to your right.
Yes, ma'am.
Next.
Okay.
Step on the right X.
Ingram, before the court on a failure to appear for possession of meth charge that was in front of Judge Clark. You understand that, sir?
Yes.
Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. Judge Clark has ordered you held without bond. Your court date is June 19th at 9 o'clock. Good luck, sir.
Let's step to your right.
June 19th?
Yeah.
June 19th.
You get a copy of it. Next. Right X. State your name.
Thomas Mayor. Mr. Mayor, before the court on an in-state warrant to violation probation out of Liberty County. You understand that, sir?
Yes, sir.
All right. Liberty County authorities request the honor of your presence. We're going to get you back over there as quickly as possible. Return date is going to be, let's go June 22nd.
That's return to court, my next court date?
No. If they hadn't picked you up, you'll come back the first appearance.
The 22nd? Okay. Tim Riley said he put in for something for reinstatement. A recommendation for reinstatement.
That's in Liberty County. This is Bay
Yeah,
County.
you gotta go
over there.
So you giving that? They got till the June 22nd to come get me?
No, they've got as much time as it takes them, but they should be here by then.
Okay.
It's no farther than that is. They should be here before then. But if you're still here, you'll see a judge and we'll make sure they're on their way.
All right, man.
Step on the T.
Step on that.
T. When the light comes on, son. Next. Next. Red X. State your name.
Joseph Sowell.
Mr. Sowell, you're for the court on a fugitive from justice warrant. It's a property theft out of Houston County, Alabama. You understand that, sir?
Yeah, I got the paperwork on it, yeah.
Okay. The only issue is whether or not you are the Joseph Sowell Houston County, Alabama is looking for. If you agree that you are, it's probably in your best interest to go ahead and sign the 5 copies of the waiver of extradition by video in my presence, putting Houston County on the clock. Otherwise, you're free to sit in the Bay County jail on dead time waiting for them to go through the process of getting a governor's warrant. What do you want to do?
How long does that governor's warrant take?
60 days.
60 days. How long does the extradition take?
Usually within a month.
Within a month.
Within a month.
We should advise him about the jail credit situation, Judge, too.
Dead time. I already told him dead time.
Oh, okay. Sorry. I blanked out. Sorry. In 60 days, sir.
That's all I can do anyway. But anyway, I'll sign the extradition paperwork and then I can do the governor warrant bullshit up there in Alabama.
No, once you go to Alabama, you don't have to worry about the governor's warrant because you're already up there. Then you just fight the charges.
Well, just get me out of here before I
sign the 5 copies of the waiver of extradition by video in my presence. Return date's going to be July 7th. Doesn't even affect me anymore. I don't even hear it. I like it registered, but I'm just.
Because you're so kind.
What's that
Judge.
say?
What?
What are you writing?
My name. Anyway.
Here we go.
Sir,
What's
this
he
is not
signing?
the name. Looks like Land of Christ.
I said Lord in Christ.
Lord in Christ.
L right here.
Okay.
See on my leg.
All right.
My name is
Here it
Adnan.
is. Back. All right. Congratulations, Mr. Sowell. We'll wait. We're going to wait for the governor's warrant. You can just rip those up. Those don't count. All right. August 7th is return date.
All right.
I can't remember, Famber. Do I have to notify the governor's office, or do y'all do that?
Yeah. I think both. I think you do
Let
too.
me go find it. Thank you, Judge.
Big dummy thought it'd be cute signing it like that, and the judge is like, all right, sit in jail on dead time. The clock's not running. Alabama doesn't have to. You're just gonna rot in Bay County till they're sick of you.
7.
And I'm sorry, Famber. We've done this one time. Doesn't Alabama start the paperwork first, and then I do my paperwork?
Yeah, but they've got to. You got to notify the governor's
You got to
office
notify that it.
and you got to call Houston County, Alabama, and tell them and see if they really want to come get him.
I know. I was trying to remember how to do this last time. I think it was the same county too. Let me work on this. Thank you, Judge.
Oh, you're
next. Critics, state your name.
Brian Lamoureux. Lamoureux before the court on an in-state warrant. It's a simple battery. They're never simple. Violation of probation out of Hillsborough. You understand it, sir?
What that? I'm sorry, I have a hard of hearing.
It's out of Hillsborough County. Violation of probation, 2 counts of battery.
Yes, sir.
We're going to hold you for Hillsborough County. Ask the Bay County Sheriff's Office to get you back down there around Tampa. Return date's going to be July the 7th. You'll be long gone by then, I'm sure.
All right, step to your right to the T. When the green light comes on, sign. Next. Red X, state your name.
John Velocic. Mr. Velocic, you're fully court charged with possession of meth, possession of less than 20 grams of marijuana, possession of paraphernalia, and no valid driver's license. You understand those charges?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true, sir?
Yes, sir.
All right, Mr. Velocic. Based on your application, I find that you do qualify for the service of the Public Defender's Office. I'm going to go ahead and appoint the Public Defender to represent you, so you have an attorney now.
Yes, sir.
Deputy, criminal history.
Yeah, show his EOS was yesterday. 21, possession of cocaine, grand theft auto ×2, controlled substance, tamper with evidence, controlled substance, battery by a detained person, VOP, 40, controlled substance, paraphernalia resisting, ag assault with a deadly weapon. It's drug charges back to 10 with the burglary.
I said 5,000 the meth, 2,500 on the pot, 1,000 paraphernalia, 1,000 no valid. Court date's going to be June 19th at 9 o'clock with random UAs. Good luck, John.
Right. Step to your right. Next. Red X, state your name.
Carol Blanding.
Mr. Blanding, you're fully court charged with uttering false instrument. You understand that charge?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yeah, that's my paperwork.
All right, Mr. Blanding, you've indicated you want to hire your own attorney or represent yourself. Is that how you're going to proceed?
Well, we're going to hire my own attorney. That's what we're going to do.
Okay.
Not exactly right now, but I mean, I guess.
Well, no, I get it. Yeah.
Yeah.
I understand that. Okay. All right. Deputy, criminal history?
No history.
Okay. I'm going to release you on what's called pretrial release. You need to report to the pretrial release office before 9 o'clock tomorrow morning here at the Bay County Courthouse. You understand that?
Yes, sir.
Your court date's going to be July the 24th at 9 o'clock.
Step to your right.
Before 9.
Next. Next. State your name.
James Basil.
Face the TV.
Mr. Basil, you're fully court charged with domestic violence with battery. You understand that charge, sir?
Yes, sir.
All right, Mr. Basil, I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
All right. Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No, sir.
Happy birthday, Greasy.
17 domestic resisting VOPs through 20. 15 3 grams of synthetic paraphernalia cocaine with intent. 14 domestic histories back to 1 local.
Bond set at 5,000. No contact with the alleged victim. Court date's going to be June 9th at 8:30. Good luck, sir.
Step to your right, sir.
What was that?
5,000. Next. Ready? State your name.
Joseph Miller.
Mr. Miller, you're fully court charged burglary of an unoccupied dwelling. You understand that charge?
Kind of, sort of, not really.
Okay. Well, have you been given a copy of paperwork?
Yep. I read it.
Okay. Not asking you if you agree with it, just asking if you understand it.
Yeah.
I understand you've been given copies of paperwork, advised of your rights, and based on your application, I find that you do qualify for the services of the public defender's office. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No, sir. Thank you.
All right. On the burglary of an unoccupied dwelling, bond set at 10,000. Court date's going to be July the 13th at 9 o'clock. No contact directly, indirectly, or through a third party alleged victim. And in case 23-2275, I'm signing a warrant for violation of probation. Good luck, sir.
All right, step to your right to the T. Next. TV. Face the TV. There you go. TV, hun. Face the TV. State your name.
Mr. Chestnut?
Yes, sir.
Sir, you're fully court charged with false report of a capital felony. Do you understand that charge, sir?
Not yesterday. I was just sleeping in a rooming house, and I heard something, and it woke me up.
Okay. I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yeah, because I got kidney failure and stuff, and congestive heart failure, and I was just scared because I stayed there in that rooming house.
Finally.
I heard something like a gunshot, and it did woke me up. And I was too scared to even get up and call.
Okay. Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. So you got an attorney now, okay? Deputy, criminal history?
Nothing since 92
92?
in Georgia. Yeah.
Chestnut, is this an assisted living facility or a boarding house? What is this?
It's like a boarding house. I was a homeless vet while I moved there.
All right.
Hey, to Chestnut's credit, he hasn't had a run-in with the law since 1992. That's pretty damn good, actually.
Release him on pretrial release. Court date's going to be June 19th at 9 o'clock. Floyd, it's a felony, so you might want to give a heads up to.
I'm already working on it, Judge.
There you go.
Because Ms. Jewell is joining that division.
Yeah, let's get the evaluation process started.
Oh, they didn't say that.
13-1.
Thank you.
All right, that's it.
Thank you, Judge.
Over here. Yeah.
All right. I did a video on this. While we're at it, I'm going to be redirecting to Big End Stream here. This clip isn't too long. But we have Mr. Flowers. He's a sovereign citizen. I've had him before, but if my day wasn't so crazy, I would have put the link to that video in the description below. As it is, I don't even know where it is. In the last couple months, I had Mr. Flowers on, just going at it with Judge Middleton.
Oh, excuse me.
You're all right.
We got Deborah. We got Mr. George.
Good afternoon, Mr. Flowers.
Keith.
Here.
Good afternoon, Judge.
Good afternoon. Keith, I don't want to be overly familiar, Keith, but I will. You're here on several cases. People versus Keith Carlton Flowers, file 22801, alleges driving suspended second offense and having no insurance under the insurance code, which was on February 9th of 2022. File number 23350 ST alleges no valid plate and again no insurance under 23349. And then 23348 ST is driving with a suspended license, second offense on February 26th. Attorney Deborah Davis can you hear me, sir? Can you hear me all right?
I can't real good, Judge.
Would you like the headphone thing? Or am I going to just speak up?
I'll speak up.
All right. That one alleges driving suspended second offense. Several of these are punishable by up to a year in jail. Ms. Deborah Davis is here on behalf of the prosecuting attorney's office. She would offer remarkably one count of driving without a valid operator's license, which is sometimes called no ops, and resolve all cases. It's a misdemeanor, punishable by up to 90 days in jail and a fine of up to $100.
That's so generous, but it makes all the sense in the world. They just want this old coot to stop driving and admit that he can't drive. Well, you'll see. You'll see it sort of works.
Plus costs, does carry 2 points and goes on your driving record. But your driving license is suspended, so it shouldn't make it any worse than it already is. Mr. George indicated that you would like to plead this charge no contest. By pleading no contest, you don't admit what happened, but you also don't deny what happened, and you allow or accept that a conviction will enter. Do you understand?
Run that by me again, Judge.
By pleading no contest, you don't admit what happened. You also don't deny what happened, and you allow or accept that a conviction will enter. Do you understand?
Well, what is the conviction you're going to have?
The conviction would be for operating without a license on a public roadway. Your Honor, I believe my client was prepared to give a factual basis. All right, well, we'll attempt that. All right. Let me ask you a couple other things. Do you understand that if you plead to this charge, there will be no trial? Do you understand that?
Yeah, that's fine, because there'll be 6 or 12 people with driver's license in their pocket.
Yes. So, all right. If you had a trial, you would have the right to be represented by an attorney. Mr. George is here to assist you. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have the right to take the witness stand and testify on your own behalf. But you don't have to, because you have a right not to testify, and if you did not wish to testify, the judge or jury could not hold your silence against you. You would have the right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath, and you have the right to be presumed innocent if and until the state was able to prove your guilt beyond a reasonable doubt. So let's go with the second one. February 9th, maybe he didn't know or arguably didn't know, but February 26th,
26, yeah.
he would have had reason to know.
Sure have got busted.
So, Mr. George, would you assist me with a factual basis? Yes, Your Honor.
Mr. Flowers, on February 26th of 2023, were you in Burr Oak Township?
Yes.
And is that in St. Joseph County, Michigan?
Yes.
And at that time, were you traveling in the driver's seat of an automobile on a public road?
Were you traveling in the driver's seat of an automobile? That was very intentional. He's just trying to get through it. I didn't catch that the first time. That's funny.
Are you the prosecutor?
No, he's asking questions to elicit the factual basis for the plea. I could have asked you, but he's assisting the court in trying to make this.
Because I'm not familiar with all this.
All right, well, he's trying to make this as painless as possible.
Because I thought the prosecutor would be here.
Well, she is here.
Are you the prosecutor?
I'm one of them, yes.
Oh, I see. Okay.
So, well, I'll ask, were you?
I demand that Deborah Davis do the factual basis.
You traveling in a motor vehicle in the driver's seat on the 26th?
I was traveling in a vehicle on the driver's seat, yes.
All right. I'm going to accept that as a set of facts. Did you have a valid Michigan driver's license?
No. No, I never have, because it was always my old cap's name that had it.
There we go. The all caps name had it.
Ms. Davis, are you satisfied with the factual basis?
Yes, Your Honor.
Mr. Flowers, anybody threaten you to get you to plead to this?
No.
Or promise you anything other than this plea agreement?
Only that I go home.
Yeah, well, all right. How'd you get here?
I paid somebody to bring me.
All right, very good.
That's been expensive.
Yes.
It's expensive when you don't have rights.
I don't disagree. Now, historically, you would get these fines and you wouldn't pay them. This is a misdemeanor. If you don't pay it, I'm going to put you in jail.
I'll pay it.
All right. Very, very good. $75 fine, $75 crime victims' rights fee, and a $50 state minimum fee. I'm going to put the attorney fee in half to $75. Mr. George certainly earned his keep here, but I wanted you to have an attorney and you were ambivalent about it, so I'll cut it from $150 to $75. $275, I'm going to give you until August 15th to pay that.
I have a question, Judge.
Yes, sir.
Do you take debit cards here?
Yes.
Now,
I believe we do.
now.
All right. The bailiffs will take you down to the court office.
Oh, okay.
And you can pay it.
This is good though. Wait for it.
And
yeah, thanks, Jim.
All right, Mr. Flowers, as we said last time, you and I are both too old to keep doing this. So how about if you don't come see me for a while? How does that sound?
Well, Judge, I don't come over and bother you voluntarily.
Well, stop driving, and then you won't have to come in here.
Well, can I travel?
You can travel all you want.
You said I could.
You can travel in the passenger seat, on the roof.
That's not what the Supreme Court says. Okay, anyway.
All right.
Thank you.
Thank you. When these matters are resolved, I'm going to need these back. And he can pay that, and then I need to put better notes in there. Good luck, Mr. Flowers.
Thank you, Judge.
There you have it. I had to follow through with Mr. Flowers. He does take the plea. He actually pleads guilty to it, but then he complains and whines on the way out that he still has the right to travel, and that Judge Middleton doesn't understand the Constitution. Middleton doesn't care. He doesn't care. He accepted the plea. There's a conviction. just run along. Looks like they're about to get paid. Oh, good stuff. Good stuff. So that was the thing. I mean, you always have problems with defendants saying too much, but oh Lord, I just looked at a few clips today. Every one of them was just, that was the prime feature. It's just the inability to shut their hole. It was fun stuff. Yes. All right. Thank you all for coming out. I appreciate it. I'm going to redirect this over to Biggin. And I guess last time he's doing the Mike McDonald case, and I guess Mike McDonald showed up. I mean, I can't verify it, but somebody named, I think it was Mike McDonald, made a scene in the comments. So always big times over there. Go check it out. Thanks a lot.